Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Recording this intro from the road after finishing the FBA Immigration Law Conference in Salt Lake City. Great conference as always, and everyone who had a hand or even a foot in putting it together should be very proud. Thank you all for an excellent conference. From my point, and in addition to speaking with lots of friends, colleagues, and government attorneys about lots of immigration issues, highlights include the introductory panel with USCIS and Department of State representatives, the T-Visa and VAWA panels, and the concluding panel with Appellate Immigration Judge Andrea Sáenz and U.S. District Court Judge William Orrick, moderated by Kate Goddell. Really great stuff. Turning back to that first panel with Department of State and USCIS representatives, did you know, for example, that you can schedule a USCIS field office appointment online now, and that soon, for some if not all applications, we'll be able to upload paper PDF application packets? Pretty happy about that, not gonna lie. Learn lots of other helpful information too. Don't get me wrong, USCIS has lots of things to work out, but this panel and the many other conversations I had this weekend were quite encouraging. Don't worry either, everybody. I personally asked a USCIS attorney to never get rid of the flutes of despair that we've all come to love. On another note, the circuit gods were quite kind to me this conference week, providing only 2 cases. First one's a biggie, too. Here they are. We all know the immense dedication it takes to be an immigration lawyer. You fight tirelessly for your clients, their families, and their futures, but let's face it, the administrative side of running a practice can feel overwhelming. Mountains of paperwork, endless calls, juggling deadlines, it can easily steal your focus and leave you feeling burnt out. But what if there was a way to simplify all of it? I want to tell you about FileVine, a legal case management platform specifically designed by lawyers for lawyers. FileVine keeps all case information centralized in one place. Plus, FileVine's immigration-specific tool, Immigration AI, uses the most advanced AI-powered technology to extract vital information from passports, birth certificates, and other essential documents, and automates USCIS form filling through smart questionnaires available in up to 170 languages. Pretty impressive. FileVine and Immigration AI can give you back precious time and energy, allowing you to focus on what matters most, your clients and their cases. So if you're ready to reclaim your time and rediscover the joy of practicing immigration law, head on over to immigration.ai/immigration review. Links in the show notes. Say goodbye to missed calls and wasted time on unqualified consultations. With Staffy Live, you get a dedicated team of truly bilingual and highly empathetic specialists answering the phones for your immigration law firm 24/7. Staffy Live specialists go beyond just answering calls. They qualify callers by asking the right questions, ensuring that only qualified consultations make it into your calendar. Plus, they don't stop there. Staffy Live can also handle follow-ups, so you can focus on what you do best, practicing law. Staffy Live is a service for immigration law firms only. And here's the best part. You can try Staffy Live absolutely free for 15 days, no strings attached. Just visit www.staffy.cc, that's stafi.cc, and click Get Started. Of course, use the code FREE to claim your free trial, or click on the links in the show notes. First is Suate-Orellana v. Garland, published by the Ninth Circuit on May 7th, 2024. Welcome back to the pod, Ninth Circuit! We missed you. This case is about deficient notices to appear, that old podcast fave, and it's a big one. Miss Suate-Orellana is from Honduras. She fled to the United States in 2011 after a gang killed her partner and then threatened her. She was deemed to have a credible fear of persecution, and so was placed in removal proceedings before an immigration judge to bring her claim. But the NTA that kicked off those removal proceedings was defective. It didn't have the date and time of her first hearing in violation of INA Section 239A. Not a toothless statutory violation, as we've now come to learn over the last 6 years. Toothless back then, though. And an IJ ultimately denied her claim. She was pro se after all, and appearing and litigating her case from immigration detention, and she was physically removed to Honduras. But she returned, and in 2014, DHS reinstated her final order of removal. Deemed to have a reasonable fear of persecution, she was placed in withholding-only proceedings to bring her claim, no longer for asylum, but only for the generally more difficult to obtain withholding of removal. She did not receive withholding. And here is where our story begins. Still here in 2018, Ms. Suate-Orellana filed a motion to reconsider with the first immigration judge, or the first immigration court at least, asking to reconsider that way old final order of removal and then terminate her underlying removal proceedings. That, of course, was because by that time the Supreme Court had just issued Pratt v. Sessions, quote, which held that a notice that does not inform a non-citizen when and where to appear for removal proceedings is not a notice to appear under Section 239A, end quote. I mean, yeah, Ninth Circuit, but it sure took us a whole heck of a long time to get there, even though, yes, that is what Pereira said and logically implied all along. Ipso facto, and even though Pereira wasn't about termination of removal proceedings at all, the argument goes that without a proper notice to appear, IJs can't even conduct removal proceedings in the first place. Now, in her motion to reconsider filed in 2018 right after Pereira, Ms. Suate-Orellana made the claim as a jurisdictional argument, like all of us were doing. But now we know that that was wrong too, because now we've all become experts in claims processing rules. Not only did the immigration judge deem the motion for reconsideration untimely, but the IJ believed that Pereira was distinct and didn't require termination, particularly 7 years post-final order of removal. The BIA agreed on appeal of that motion to reconsider denial. Although the BIA pivoted a bit, it held, based on its now defunct precedent, but at the time, funked precedent, that the follow-up hearing notice that Ms. Suate-Orellana received made the NTA deficiencies A-OK. That ruling ended up actually being pretty good for Ms. Suate-Orellana procedurally, because the Ninth Circuit here doesn't see the timeliness, or lack thereof, of her motion to reconsider or equitable tolling issues before it. Rather, it sees a straight-up deficient NTA termination case, post-reinstatement of a final order of removal to boot. Alright, Ninth Circuit, what you got? First, jurisdiction, as any good court addresses and as any good oil attorney argues. Deficient notices to appear implicate claims processing rule violations, we all know that now. But Ms. Suate-Orellana brought only jurisdictional-based arguments to the IJ and the BIA way back when in her motion to reconsider. So oil argued that Ms. Suate-Orellana had failed to exhaust her argument. Kind of a cousin of jurisdiction. A very narrow view of exhaustion requirements, but one that many circuits or even some Ninth Circuit panels might agree with. Not this one. Quote, a non-citizen need not raise a precise argument before the BIA in order to exhaust it, end quote. And Ms. Suate-Orellana's core argument was that the NTA was deficient, thereby making removal proceedings and the removal order improper. This was enough, particularly as the BIA totally got what she was arguing and then rejected it with its relevant precedent from the time. Here's a quote for all of your listening pleasures for all your old cases. Quote, while Ms. Suate-Orellana did not use the phrase claims processing violation in her briefing below, she was not required to use precise legal terminology to exhaust her claim, end quote. Even the BIA didn't shift to claims processing rule territory until after Ms. Suate-Orellana's briefs. To hold her failure to make a claims processing rule argument against her is just too much, explained the Ninth Circuit. Her core argument was that the purported NTA wasn't an NTA. That was enough, everyone. Now, although the Ninth Circuit doesn't come out and say it, the BIA's rationale here from 2018 denying Ms. Suate-Orellana's claims is clearly wrong today. Case law has changed a lot, including even the BIA's. And so for that reason alone, it seems, the Ninth Circuit sent it back for re-evaluation. Notices of hearing don't save deficient NTAs anymore, everybody. Here's where it gets really interesting, though. Assuming you're not already in a legal frenzy and can still think, based on what I've already thrown at you. Oyl argued that all of this was unnecessary because INA Section 241A5 clearly divested the IJ and the BIA of reopening or reconsidering Ms. Suate-Orellana's removal order after DHS reinstated that removal order. Yes, indeed. Can't wait for this. OMG, quote, we hold that Section 241A5 is non-jurisdictional, and that the BIA therefore may, as it did here, exercise jurisdiction over an appeal concerning a motion to reopen a reinstated removal order, end quote. God bless you, Santos-Zacaria from the Supreme Court last term. God bless you. And if you were listening, the Ninth Circuit said motion to reopen, not motion to reconsider. Reason to the Ninth Circuit, Section 241A5. Like the INA Section 242D1 statute at issue in Santos-Zacaria, doesn't expressly have jurisdiction stripping language in it. That means, under the Supreme Court's recent logic, that it's a claims processing rule that can be waived or excused. That makes this case about a claims processing rule that can be waived so that the BIA can consider DHS's own violation of a different claims processing rule. We truly are in our claims processing rule era. Lots of other reasons used by the Ninth Circuit here to say that Section 241A5 is not jurisdictional, but who cares? Review the decision to make the argument in other circuits, of course, but really at base, the argument is that if the statute doesn't expressly say that it strips the IJ or the BIA of jurisdiction, like some INA statutes do, it's not, following Santos-Zacaria. To the extent that pre-Santos-Zacaria Ninth Circuit precedent said otherwise, it doesn't matter. To quote The Rock during his People's Champion days. And of course, to paraphrase the Ninth Circuit. Supreme Court precedent is powerful stuff, as is the Supreme Court, so vote like your rights depend on it. Unfortunately, that's about the extent of this Ninth Circuit decision here. The court doesn't say anything about the merits of the argument, that is, when, if ever, it's appropriate to reopen or reconsider and terminate long-closed removal proceedings for NTA deficiencies, and when, if ever, the non-jurisdictional Section 241A5 can be overcome post-DHS reinstatement. But we've got a chance. And I imagine this is only the beginning. Unless, of course, the Supreme Court shuts the door really hard with its deficient NTA in absentia decision this month or next. Anyway, though, big congratulations to Jessica Rofe, Naomi B. Sunshine and Nancy Marowitz, and NYU law students Jency Paz and Vibha Khan for petitioner. Not to mention Trina Realmoto and Kristen McLeod-Ball from the National Immigration Litigation Alliance on amicus for that same entity. I feel like Trina gave me a heads up that this case was coming down the pike pre-interview a few months ago. If that's the case, there is no way to check me on that as we weren't recording yet, so let's go with she did. Congrats to all. And I've got a little more. I'm not going to lie, I was wondering why this case was traveling under a motion to reconsider posture rather than a motion to reopen. Where, after all, I doubt Ms. Suate-Orellana ever argued for termination in 2011, and the matter had been final for like 7 years when the motion was filed. A motion to reopen seems to be more proper than a motion to reconsider under those circumstances. Reading the decision, I suspected it was because Ms. Suate-Orellana's counsel may have thought that while motions to reopen are barred by INA Section 241A5, there's an argument that motions to reconsider aren't. The Ninth Circuit didn't discuss any of that during the case. Until the very final footnote on the very final page, that is, quote, in light of this conclusion, we need not consider Ms. Suate-Orellana's separate argument that Section 241A5 does not apply to motions to reconsider as opposed to motions to reopen, end quote. What are your arguments on that one, though, counsel? Section 241A5 seems pretty broad to me. Share your arguments with me. And that is Suate-Orellana v. Garland. Concluding then with Galvez-Vicencio v. Garland, published by the 8th Circuit on May 6, 2024. This case is about reasonable fear review. Mr. Galvez-Vicencio is from Mexico and has entered the United States without authorization more than once. On his last re-entry, he was prosecuted criminally. DHS reinstated a previously final order of removal against him, but before they could physically remove Mr. Galvez-Vicencio, he expressed a fear of return to Mexico based on cartel violence. That entitled him to a reasonable fear interview with an asylum officer. The asylum officer did not believe his fear reasonable, though, and an IJ affirmed that finding. To the extent Mr. Galvez-Vicencio had been harmed and feared harm from the Cartel de Jalisco Nueva Generacion, the asylum officer and the IJ believed it was on account of a personal vendetta against him and not because of his membership in any particular social group. The 8th Circuit affirmed. Mr. Galvez-Vicencio doesn't even get the opportunity to bring his full claim for relief and protection in immigration court. The 8th Circuit affirmed the no reasonable fear finding, based on nexus, though. Credible fear and reasonable fear interviews are kind of weird like that. Kind of mini adjudications that sometimes bleed into the full-fledged adjudication. Before getting to that, though, not for nothing, the 8th Circuit did not even question whether it lacked jurisdiction to review the no reasonable fear finding for any reason, including for any 30-day rule reason. There is all that recent precedent tethered to the 30 days, for example, and here that final order that was reinstated was, after all, issued in 2009. So in the 2nd Circuit, and I believe the 6th Circuit, but maybe the 4th, I can't remember, you wouldn't be able to get review here. Perhaps OIL didn't make any jurisdictional argument in this case. Either way, not discussed, so who am I to do so anymore? Mr. Galvez-Vicencio, though, lost on the merits. It seems that the proffered particular social group was his family, and well, the 8th Circuit issued some non-citizen adverse holdings on it in this case. Quote, to constitute a family with visibility, we have explained that the members of the group are perceived as a group by society such that these individuals suffer from a higher incidence of crime than the rest of the population. Without more, a family experiencing gang violence is too broad, end quote. Not socially distinct in the 8th Circuit, even though it's a family. After all, here, explained the court, Mr. Galvez-Vicencio's mother and brother live safely in Mexico, and they're part of that group. And although his other brother appears to have been kidnapped in Mexico, and Mr. Galvez-Vicencio is himself listed as associated with that brother by the Mexican prosecutor's office, the 8th Circuit didn't believe that any risk to Mr. Galvez-Vicencio was because of his family membership. Seems like there's a bit more going on in this case, but it wasn't really discussed in this short decision. The other generic evidence showing that cartels and gangs in Mexico target those who have helped police didn't save Mr. Galvez-Vicencio's claim, said the court. Nor did the panel see a Convention Against Torture claim, even though this is in the significantly reduced context of a reasonable fear interview where Mr. Galvez-Vicencio need only make a threshold showing. Mr. Galvez-Vicencio, therefore, lost his case. Permit me to gripe, 8th Circuit. Not about this case, but about all cases. See, as I told one of the 8th Circuit's very helpful and friendly clerks over the phone last week, the 8th Circuit used to be the best out of all the circuits in how they report their precedential decisions. Not only did the 8th Circuit's RSS feed work routinely, but the 8th Circuit also listed whether a case was precedential or not right there in the blurb, and unlike any other circuit, issued a 1 to 3 sentence blurb about what the case was about and what it held, for every case, on its daily page and in its RSS feed. It was exceptionally helpful. But very recently, no longer, and I have reason to believe that it was intentional. Why, 8th Circuit? Why? You were the best! Now, I fear you were the worst. It need not be so. While 3-sentence blurbs might never come back, is it too much to ask for a parenthesis stating whether a case is precedential or not, and a space between each listed case on your website? If, of course, anyone in 8th Circuit land is listening. And that is Galvez-Vicencio v. Garland. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview, that's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.